most folks are in that are coming in. So I'd like to welcome everyone to the second day of the Nevada Juvenile Justice Institute. As a reminder, my name is Jessica Pierce. I work at the National Council of Juvenile and Family Court Judges as a senior site manager, and I have the privilege of being the curriculum shepherd for the Nevada Juvenile Justice Institute. I really enjoy helping people create engaging and interesting presentations and materials. And with the Nevada Juvenile Justice Institute, we have this amazing opportunity to create not only these live sessions that you're participating in, but also our series of recorded sessions that are going to have short presentations in addition to implementation guides, note-taking guides, so that you'll be able to participate with those materials and then really go out and think about how you might change your practice or change things within your own system. So I'm hoping it'll be a really useful tool, not only through September, which is when we're awarding CLEs for the project, but also as you move forward in your career on the bench. And so with that, I'd like to welcome everyone to our session today, which is going to be all about judicial leadership and ethics. I am joined today by two titans of the judiciary here in Nevada. We have with us Justice Seda and Judge Egan Walker, and so I'm going to ask you both to introduce yourselves. Justice Seda, you go ahead.
Good afternoon. Thanks for joining us. I've been around for so many decades that I think that we'll just jump into the meat this effort. I've had the privilege of sitting as a trial judge and an appellate judge, and the privilege of working with most of you, and I am just proud to be a part of this process. Judge Walker.
I think most folks on the platform know me. My name's Egan Walker. I have the privilege of serving in Department 7. Let's begin with, I hope, some self-deprecating humor. You all know the only way I'm a titan is in waist size. I'll simply be here to aid Justice Seda in the conversation.
I'll reserve comment on that, but I think the beauty of this presentation, aside from content, of course, is the fact that we are all, most of us, know one another. We have worked together in one coordinated effort. Titans or not, we all care about the kids and families that we serve, and that's what we're here to talk about today in these trying times. So, Jessica, tell me when you want us to get into the meat and potatoes.
Wonderful. I think one of the things that I want to start out with is asking our audience, what ethical challenges do you encounter in juvenile court? I think that juvenile court has different challenges than other parts of the justice system in some ways. And so I wanted folks to write in chat, or if you want to, you can talk out loud. You just have to raise your hand and I can unmute you. To raise your hand, you're going to look for an icon of a person with their hand raised. It should be right above the PowerPoint, and I can unmute you. And of course, Judge Voice, since you're already unmuted, you can just chime in. But what kind of ethical challenges do you encounter in juvenile court?
I'm not sure if we're seeing a lot of writing, but I do want to encourage Judge Walker and Jessica and I have prepared this presentation with you all in mind. So the interaction is going to be far more important than anything that we will say to you. Please feel free.
This is Judge Voice. If I can chime in.
Sure.
Yeah, I think that we encounter ethical challenges as judges every day. I don't care what law, what case type you're handling. There's ethical challenges that come all the day. What's unique about the juvenile justice system is that it purely is a creature of statute. It is a kind of it's the first specialty court ever created in the world, actually, back in 1900. And with that, it was a combination of traditionally executive branch functions and judicial branch functions merged together to form the juvenile court. It's the most unique court system, in my opinion, that exists because of that. And if you look at, especially in Nevada under Chapter 62, where you have this really unique area where the legislature has granted the authority for the judiciary to act somewhat in an executive capacity in their role as the juvenile court judge over the juvenile system. Now, obviously in Nevada, we've got a split system with, in Clark County, for example, we have the executive branch that oversees and does the Department of Juvenile Services, whereas in Washoe and the rest of the state, you're the traditional model of where the probation officers and detention people, things of that, are all come under the court system like your court clerk does. So that's a very unique area of the law, and of course will present from time to time challenges on how to walk that rope between the so-called separations of powers that we have to recognize. And I think that's usually one of the biggest challenges that comes up that's unique to juvenile court, is walking that line between being a neutral, detached judicial officer, but then also responsible for overseeing and coordinating the efforts of what are kind of seen as executive branch functions like probation officers, detention facilities, and things of that nature. So those lines become difficult to walk, and so that's where I think where most of the difference between the juvenile justice, case load versus, let's say, your standard civil practice would come into play.
I think, Judge Boy, that you summed up what we've seen come into the chat, because it looks like a lot of our comments are about that idea of where the boundaries are in juvenile court. And so on one hand, you have that idea that, especially because we're working with young people, wanting to know more about their lives and working to build that rapport, and really wanting to make sure that we're doing the very best we can for kids, and where is that line where we might start to overstep. And then the other side of that is the idea that a lot of times there are casual conversations that are happening with probation officers, with other folks that you might encounter in like the hallway, and how do we make sure that there's no appearance, I think, of propriety. So I'm going to ask Justice Seda and Judge Walker if you wanted to kind of talk about these questions now, or if you want to save them, because this is kind of one of our already designated areas of conversation.
Let's go with the questions.
All right, so let's jump into that, that idea of establishing good boundaries while also wanting to make sure that we're doing the best we can for the kids within the court, and also when we're overseeing probation and those folks.
If it's okay, Justice Seda, I'll jump in. Jessica, would you enable me to share my screen, please? I think it's always important to begin with the statutes that control how we operate. And the statutes that control how we operate are at times inconsistent, confusing, but also invite challenges for judges. So on my screen, you all should see a matrix of Chapter 62D, H, E, and 432B from the NRS. Again, thinking juvenile justice, for me, juvenile justice includes child delinquency and child dependency. They're often, but not always, the same kids in the same jurisdiction. And the language of the enabling statutes is challenging. For example, in Judge Voy's jurisdiction, that is a jurisdiction with more than 700,000 human beings, child dependency hearings are presumptively open. Child delinquency hearings, 62D010, must be open to the public in all jurisdictions. And the statutes that describe what judges can use are very broad. So for example, in 62D420, the juvenile court may review records relating to the custody of the child or involvement of the child with an agency which provides child welfare services, shall afford the parties and their attorneys an opportunity to examine each written report, may receive all competent, material, and relevant evidence in addition to written records. So the statutes are very broad in terms of the information that a judge can consider. Master Dollinger, for example, in Washoe County, her courtroom is embedded within the juvenile probation facility. She literally walks by juvenile probation officers to get to and from her chambers. And I'm sure there are challenges for her to not share information in an ex parte way with the juvenile probation officers about the children. The court, of course, has discretion to review almost any information it thinks is relevant. However, all information reviewed by the court in the child delinquency context must be provided to the parties and their counsel, who may examine and contest that information. So not only is there the overlap of ethical considerations like ex parte communication, but in the juvenile delinquency context, there's the additional statutory overlay that requires that the court reveal to the parties the information it is considered for purposes of handling a child's case. You each will see links at the bottom of the Adobe Connect to these statutes and my editorialization about the practical effect of the statutes. But now more to the point of the question, and I'm going to stop sharing my screen at this juncture. More to the question is the point that I think as judges, and I very much appreciate Judge Voy's perspective, that we sit in an executive, or what would be normally an executive position capacity in many ways, to simply do the best for children. Judges, I think, always have to skew toward a legal basis for the action they take, an open dialogue with the participants about the information they're using, and communication that is not in an ex parte basis. Those are my best suggestions. Justice Sayre?
I think that the point about following the checklist that you've provided and or buying through our reporters is step one, and is probably the wisest way to convene an ethically appropriate hearing. The problem is, and that we face as judges, is if you read through those controlling statutes, some are permissive, some are mandatory, and I think that it is, as Judge Walker ended on this point, it is extraordinarily important for the judicial officer, be master or judge, to share with those who are in their courtroom. I have reviewed this pursuant to statute, whatever, 62, number. I am happy to share that information with you. I think, again, open communication about what the judge is reviewing and the authority upon which they are relying is the key to maintaining an ethical courtroom with all of the intersecting different pieces or spokes of a wheel that we see in this area. Abuse, neglect, JJ, our specialty courts now with drug treatment of parents. There's so many intersections that I think a matrix laid out on your bench of what you can do, what you must do is the key. Just, do we have other questions? Or shall we move into the next?
We don't have anything else that's come into chat, so let's move on to kind of what we had thought about talking about. And let's start with confidentiality.
Let's go into the specific requirements of confidentiality. Judge Walker.
So again, Jessica, if you would allow me to enable sharing my screen, I want to go back to the matrix that I built for our consideration and just point out what I think are some of the challenges in addition to the kind of inconsistent points. So not in the matrix, everyone will recall again, of course, that there is a restriction on the admission of persons to a child welfare proceeding. It is population-based. So in the statute, there's a presumption that Las Vegas, which is the only city, of course, with more than 700,000 people, would have open hearings. And in Washoe County, where I work, there's a presumption that those hearings would be closed. This can create challenges, particularly in crossover youth hearings. I would suggest, however, that you can find the exception you need in any of the statutory provisions. So I'm referring, for example, to Chapter 62, where a juvenile justice agency may deny a request for juvenile justice information if the request does not demonstrate good cause, but may also open records of any case to inspection by a court order to persons who have a legitimate interest. And so in a crossover hearing, for example, the juvenile justice agency can share any information the court or the agency deems is appropriate. Likewise, on the child welfare side, is a wonderfully broad provision that instructs that nothing in the provisions of Chapter 432B prohibits an agency which provides child welfare services from sharing information with other state or local agencies. And 432B 430, which discusses who may be admitted to hearings, always gives an out. It says the hearing must be closed in a population base less than 700,000 to the general public unless the judge determines that it's in the best interest of the child to open the hearing. And so there, I find that although Chapter 62, Title 5, which is all of the subsections of 62, is confusing and inconsistent in many ways, to my eye, there's always a loophole, for lack of a better word to describe it. There's always a way to find statutory language that will let me get to the place we need to get for the benefit of the child. I remind us all that 62D requires that hearings be open to the public. For purposes of conversation, I wonder, Justice Seda, if we might invite Judge Boyd, I'm going to stop sharing my screen again, to opine as to when he closes a child delinquency courtroom to the public, if ever. Because it creates some interesting challenges for he or Master Dollinger, for example, who does 90% of, or 95% of the juvenile delinquency hearings in Washoe County. I think it creates a challenge to both weigh the interests of a child and their needs in privacy and the interest of the public in having an open hearing.
I think that's a good idea. I want to emphasize and ask a question because I think that Judge Boyd can answer this in the follow-up as well. Some of you may remember an ill-fated bill. It was SB 31 that had to do with information sharing that after several sessions became part of what Judge Walker just read to you. Here's my concern about that statute, and I'd love to hear both of you comment on this. The language about release of information is often modified by deciding what is appropriate. When it is not left solely to the judge, for instance, in the determination of whether the proceeding should be open, but in just release of information, Judges Walker and Judge Boyd, who decides what is appropriate, and can the HIPAA statute be used to bar release of information? And if you have any examples of how you deal with that in your courtrooms, I think it would be helpful for our audience to discuss that. Either Judge Boyd?
There's Judge Boyd. Let's do a clarifying. So there's two different areas. We're talking about release of information within the court process in open court versus a release of information pursuant to the statute that goes outside of the court. For example, a request for release of information, for example, right? So there's two different venues, or whatever you want to call it, where the release is occurring. And so in the open court, I've always taken the position, that's why we created because we talked about the crossover youth and that unique issue of, yes, presumptively open for delinquency, but then, closed for dependency. One of the genesis behind our creating the dual calendar for our dual jurisdiction kids, where the kids are, and usually they're the calendar, most of the kids that appear on that calendar, they're very difficult placement issues, very, lots of mental health issues, very complicated cases. So we've taken the position that the virus has actually helped us a little bit in that regard, because using the alternate means of appearing, it pretty much eliminates the general public anyways. And so we have a situation where we created that so that, and we do routinely exclude folks that have no other business being or involved in the matter. If they have a legitimate interest in what's going on, let's say a victim of kin that doesn't necessarily have placement but would like to have placement, things of that nature, we'll allow those folks to be participants in on those dual calendars. And usually what I make sure that the attorneys are that concur with that decision, right, on the record to protect yourself. And so it is a difficult area because you're walking a line there, and I don't know any other way around it other than what we've done ad hocly, case by case, and creating that special calendar just for those, again, this crossover youth, where we're talking about both aspects of the case, and on the JJ side and on the dependency side at the same time. And so that's kind of how we kind of handled those situations. But in the open court venue, outside the court venue, as far as the release of information, you've got to strictly follow the statute, and legitimate interest in those records is that you could drive a truck through that, through that definition, right? So it becomes very, very challenging from time to time. And usually I found over the years, 17 years of doing this case type, that the legitimate interest is usually has to do with a relationship with that child in some form or another that makes it a legitimate interest in that information to be released. And so, and also the other thing is, we were talking about the court process, but there's the whole other statute that talks about the release and flow of information between law enforcement agencies, the departments, on both on the dependency side and the Hello? You there? There's a dog out here in front of the hospital. I'm sorry. I'm sorry about that. Where it came from. Anyways, and so it is very challenging. And usually when there's any question, it's put on the record, everyone's there, and I'll state on the record why I think this is a legitimate interest, and give the attorneys at least an opportunity to opine one way or the other. And 99% of the time, the attorneys have been, have been okay with it. And so that's how I've kind of watched my backside, so to speak, as they say, as long as you bring that into the open court process. So that would encourage that strongly about any kind of request for information like that. When in doubt, put it in the record, do it in open court. That's what I've been doing over the years.
An example of what Judge Boyd describes in my practice is frequently we have children who become, for example, pregnant. They may be accused of a delinquent act. They may be a victim involved in a delinquent act. They may, in some other manner, be involved or have a legitimate interest in the case. And I see Master Dollinger offers an appropriate question. Well, how do you manage the fact that a victim may want to appear and make a victim impact statement pursuant to statute, but you also have to disclose or discuss during the hearing what would be HIPAA protected or other confidential information, for example, the status of being pregnant. And so to Judge Boyd's point, I think bifurcating, or for lack of a better word, chopping up the proceedings so that different persons have different access during their section of participation in the hearing to the information is critically important, and is too provided for both by 432B and by Title V. In the end, of course, to Judge Boyd's point, I think the purpose is to protect information that would otherwise be damaging to the child or children if disclosed in an inappropriate way.
So
I can add to that also. One of the techniques we use over the years is because usually that information that you're talking about is super sensitive information, right? And let's say you're strictly in a 62 proceeding. it's already in reports that both the DA and the kid's attorney and the kids have seen, and that information is before the court also in written reports, right? And so I'll do a sidebar from time to time with the attorney and say, okay, we all know this is a particular issue, let's say the pregnancy, right? But we can reference that there are issues, but we all know what that is. So when on the record with other folks listening, let's keep the detail out. You can reference it generically, saying there's some issues that we're all aware of, and then we'll and we sometimes will handle it that way, so that you can keep the flow of the hearing going and get your cases through, right? I mean, you don't usually have more than one case a day, for example, right? The lecture is sitting there for 3 or 4 hours on one case, and then you'll make a record after the fact of that, just so that it's noted in the records that everyone was aware of that information, and that can be part of your formal record, and you can put it in your written order, for example, because the difference between the open hearing, the records are still sealed, they're still subject to being following the statutory criteria to get that information, right? You don't necessarily have to have that repeated in open court per se, and I've taken that position, right or wrong, I've taken that position. So it may be in the record, but there's some safeguards there. When it's said in dialogue in open court by the attorneys in their argument, for example, well, if it's an open hearing, then it's all out there, right? And so sometimes you'll do it that way, if that makes any sense.
So I heard two options: bifurcate, essentially trifurcate, chop the proceeding up in order to protect both the right to be heard and certain privacy rights, and then to use a pre-proceeding agreement on how some of the sensitive matters will be referred to during an open hearing, with a follow-up record to be sure that everything is clear and transparent in the record. Master Doninger, did that answer your question? I hope. If not, please let us know.
Justice Seda, I might offer a cautionary tale at this juncture, if you don't mind, about so-called Zoom bombing and other invasions into proceedings.
Yes, please tell the reality that you encountered last week.
So unfortunately or fortunately, we're all in this virtual environment. In other words, we're not meeting with people face to face, which has its challenges, particularly in my mind, when you're trying to communicate effectively with children, but we're really with any human beings. The issue, though, that has come up for me, for which I have few answers, I fear, is illustrated in this way. I have a mixed docket, a mixed general jurisdiction docket. So it has juvenile issues on it, it has traditional quote-unquote family issues on it, and a guardianship docket, etc. Last Friday, I was in the guardianship docket, and we post in the second the URL connection to public hearings, criminal, civil. In this case, guardianship is a civil, but an open hearing by statute. And so we post the public link, the way the public can participate in the hearings, on the website, the Second Judicial District Court website. We use the Zoom platform. I think many people have a favorite. Today we're on Adobe Connect. Justice Sada, I think you shared with me in the 8th, they're using BlueJeans. I know the state prison system is using BlueJeans. But here's the challenge I offer to everybody, or the cautionary tale. I was in the middle of the docket on Friday in the third guardianship case, and an attorney named Homa Woodrum, who works for Aging and Disability Services, had been admitted to the Zoom hearing. Knew who she was, knew her name. There was a second Homa Woodrum who appeared in the attendee list. We were using a particular platform, if you will, or forum in Zoom that allows us to promote people from the attendee list, much like the participant list in this platform. And the second Homa Woodrum got promoted because on occasion in the Zoom platform, you'll have an audio appearance by a person and a video appearance by a person. They will literally have two boxes identified to them for reasons I don't completely understand. So the second Homa Woodrum was promoted. whoever it was then was able to hijack the chat box in Zoom, enter malicious code, and take control of Homa's identity. They then shared their screen using Homa's identity and displayed what I believe was child pornography in the middle of the public hearing. And were chanting, "I can't breathe, the cops are killing me," and then very vile, racist, and bigoted other statements. My remaining option was to kill the Zoom meeting. In other words, to turn it off. But to the point of confidentiality that we've been talking about, I think we all need to really consider the pros and cons and weaknesses of how do we maintain the integrity of the hearing, and then how do we as judges control what happens in the hearing. Even more worrisome, an hour after my hearing was Zoom bombed, Judge Simons, who's another general jurisdiction judge, was also Zoom bombed. And in her case, the person who hijacked the hearing used the same method, in other words, the duplicate ID method. But they displayed, when they displayed the share screen, a bomb threat to one of the attorneys who was a participant in the case, with a picture of the attorney's home taken from Zillow. And it's very dangerous conduct. You know, somebody had to take a lot of time and do a lot of planning and intentional activity to undertake it. But for purposes of our conversation, I think it adds another layer of concern and consideration to judges as they manage the hearings. What am I going to do if it is a presumptively public proceeding, as juvenile delinquency cases are? How am I going to make it available to the public? And then how do I control who joins and what they do in participation? I offer that just for people's consideration. It's fresh off the presses, as it were. It happened Friday.
And along those lines, because I think that Judge Walker made it very clear that the court does not yet have an answer to how to prevent or protect against that type of Zoom bombing, other than to shut the proceeding down. But here's another question about challenges in confidentiality. You know, we are now doing our hearings, oftentimes, as with me today, this is my home. You're in my home. What are the challenges when you are reviewing a case, either delinquency or a 432B case, if you see something in a home environment that troubles you, something that you would not otherwise see if those participants were in front of you in a courtroom? We talked about this about a month ago in the national conference for the council, where a number of judges experienced this. They're now sitting in the living rooms or the dining rooms or kitchens or cars, in some instance, of the people who are appearing in front of them. What information are we gathering just by being in someone's home environment? Have any of you experienced that, and has it been a challenge to your decision making or your consideration of the case that's currently before you?
This is Judge Boy. We've had a few interesting sessions where people have appeared on the Blue Jeans app, which we use down here in Clark, and the first thing we have to remind people when they're on is that you're in open court, everyone can see you, and everything's being recorded. That's the first thing we usually say when we start, before we even get on the record. I've seen some interesting things in the last few months. That's fortunately, it hasn't necessarily been something that's impacted the decision that's relevant during that particular hearing. But I can see where it couldn't very easily do so. I was going to mention a moment ago that one of the techniques that we started, and again, we were handed Blue Jeans on a Monday morning on March 16th, I believe, and told to use it with no prior education about how to use it or what to do. I had to chase my lawyers out of the courtroom, told them to go back into the parking lot, and here's the app, you can download it, and here's the code to get in. And so starting off with not knowing, so what we developed just because we were given no other instructions was basically, if I'm doing a dependency case, more importantly, rather than delinquency, but we still did the same observations. My clerk watches the board as because you can see people, wanting to come in or are coming in to the actual proceeding, and we routinely, and especially in the delinquency case, we don't recognize on the dependency side. We don't recognize that number. Is that not someone that's been involved in the case, and you've got your caseworker who can acknowledge, okay, yeah, I recognize that number. That's the parent or whatever, right? But if we don't recognize it, no one else does. And also my DA keeps an eye on the same board from their screen, from their office, and they'll chime in occasionally, hey, I see a number on the board that says blah, 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 and we'll kick them out as soon as we see it. And so we've had to develop that practice of routinely kicking people out that we don't recognize, especially in the dependency cases, of course, and to some extent the delinquency cases. And we just have to monitor that way because, as what Judge Walker said, it's a difficult time, and you just have to be mindful of it and develop whatever practice makes sense for you and whatever technology you're using to be able to try to avoid the situation described by Judge Walker a few minutes ago. And that's how we've kind of developed it over the last 5 months now. If someone's got a better way of doing it, I'm all for it. But right now we're doing the best we can with technology that we were introduced to in tough times.
So Judge Vega, I think, offered insight. I think it's analogous to the plain view doctrine. Everyone is in control of their own viewing screen environment, and what is on the screen is put out to the public, which I agree with. There are some humorous things. I love Master Dollinger's examples of people eating their breakfast during the hearing. I had colleagues who were doing a divorce case, and the plaintiff and defendant in the divorce case called from their mutual bed under the covers and gave testimony about their property distribution while she leaned her head on his shoulder while they were laying in bed. There's just a variety of circumstances, but more germane, I think, to our comments is this platform, in my opinion, is a ton more work for the judges. Our responsibility is huge. Managing the participants is much more difficult in this platform than in any in-person platform I've ever dealt with. And to Judge Voy's point, I think we're just struggling through trying to make the most of what we can do. It has, to Judge Dollinger's point, some good implications for Bridges Out of Poverty. We meet people where they're at, when they're at, in a way that they can meet with us, which is good. But again, just last week, I had a defendant in an adult case appear for a very violent burglary sentencing, having made bail, drinking a beer, shirtless next to the pool. And it's very difficult to manage situations like that.
Let me throw in here on this one. I think it's a great point. And Justice Seda and Judge Walker would appreciate this. The other day, one of my DAs, who appears obviously by video in his office, he had this obnoxious banner in the back on his bookcase shelf. We all see it. And I warned him. I said, you need to take that down because, it's visible and everyone's seeing it. And he said, oh, well, what can I do? And so it stayed up there for a couple sessions. And all of a sudden, I see my marshal in his office taking it off the wall. And then she comes back into my courtroom because they're just down the hallway, right? It was a Unr Banner. So, so you just never know. So I told him he couldn't display that here down in Clark County. But anyways.
I think speaking to that point.
We gave it back to him eventually.
Speaking to that point, I think one of the things as judges, when we talk about boundaries and not just the specifics of confidentiality, we need to be ourselves mindful that the proceeding is still a judicial proceeding. I think we need to remind those in the virtual world that we will be robed. I presume all of you wear your robe even when you're virtual. and you expect the same type of decorum from a virtual platform to the extent that the parties are able to comply with that. I'm not so sure about a UNR flag, and I'm not going to get into that right now. We can do.
Well, if you're down here in Las Vegas, it's a totally different story.
Understood. Understood. Jessica, do we have questions regarding challenges to confidentiality in the virtual remote world?
We kind of covered everything that has come up. Judge Walker brought out some of these things that Master Dollinger was asking about, and then we've had a great discussion here in chat, lots of folks sharing their different things that they've encountered, lots of shirtless folks come into court, and I think you're right that it really is about that messaging about this is still a formal proceeding and that these are the expectations of participants. But with juveniles, yesterday we talked a ton about adolescent development and juvenile behavior, and so one juvenile turns their back to the camera in a show of dislike for what was happening to them, and that's, I think, a good example of typical juvenile behavior that can happen in court, and thinking about how to respond to that in a way that is still thoughtful about how that's a normal adolescent behavior and we shouldn't criminalize it, but we also want to help kids understand the importance of coming to court. So figuring out how to walk that balance. It's not an ethical issue, but I think it's definitely one that we're going to encounter a lot with kids.
I think the psychological rapport that this particular specialty area requires is certainly very difficult. Judge Walker mentioned this. It's much more difficult in the virtual platform. And I think that one of the things that I'm hoping for is that we will all learn better skills on how to relate to those who are before us in the virtual platform. As a simple recap, basic confidentiality about these proceedings is set forth by statutory mandate. Once again, it's a checklist for each and every one of the judges. Some of the confidentiality is, I think I will coin the phrase that Judge Boy used. He believes that the statutory language is wide enough or ambiguous enough to drive a truck through it. That is where the judicial creativity should come in to protect what we are seeking in that proceeding, use that creativity to reach the truth and the best result for the kid and families who are in front of us. I wish that we had answers to the remote or the virtual platform dilemmas. The Zoom bombing that Judge Walker has described is frightening to me. And, the mechanism of control that Judge Boyd pointed out, where he has sort of a couple of backups watching who's signing in and out of the platform, is great. I'm not sure that all of our judges or judicial officers would have that opportunity. And these are challenges that I hope we can come together in a couple of months and have solutions for these challenges, so that certainly none of the judges will face what you faced in the second, Judge Walker. I think we better get to our next slide.
Okay, so we're going to shift gears a little bit, and we're going to talk about what judges should know about record sealing and expungement.
Judge Walker, I'm going to bounce over to you. We have
Well, thank you. So generally, we all know that record sealing is now and should be an automated task based on age of the child and nature of the offense. What I think we need to discuss about record sealing and expungement, however, is how it's actually working. Here's what I mean by that. Let me share a blemish on the record of the second, a solution that I was not able to solve when I was the judge responsible for the juvenile delinquency business unit, and one that remains. So record sealing and expungement should happen in an automated way. In almost every hearing where she undertakes a formal adjudication, for example, Master Dollinger includes a sentence or a blurb at the end of the order indicating, if it's available based on the particular charge, this child's record shall be sealed on their 18th, 21st, 28th birthday, as the case may be. And that's a commendable practice. What is unsaid is that there are thousands, literally decades of records worth of juvenile records that haven't been sealed in the second. I suspect the same is true in other jurisdictions. And I'd be curious to know people's thoughts about it. We also, as a state, have not, as Master Dollinger is pointing out in the comments, formalized what the process is to seal the record. So, for example, I've signed hundreds, if not thousands, of sealing orders saying this child's record shall be sealed on their 21st birthday, but I then transmit it to every police agency in the county, and the question legitimately comes up, am I creating a record for that child by doing so? Be interested to know, Bill or Judge Boy, your thoughts and any other comments from any of the other participants.
I'm gonna your last comment is kind of intriguing to some extent, because what we've found is obviously our orders also reflect the statutory language in our standard probation order for the automatic sealing. What we're finding, and we do the automatic sealings all the time. What I find is that the attorneys are bringing cases on that should have been sealed, were sealed, but the other agencies, let's say for your law enforcement agency, hasn't sealed it. I mean, the only way you can, unfortunately, as you stated, you send out the notice telling the law enforcement agent to seal the record, and so that's creating a record by itself. I get it. But what I've been finding is that even though they get the order to seal, they're not sealing it. I've had several cases over the last few years where there was investigations done and information that was in the hands of the law enforcement found its way into the affidavit of arrest, and one of the reasons for the arrest was that additional information that was should have been sealed and was not sealed by that agency. And so it's kind of a catch-22, but I find more often than not that the law enforcement agencies are not following through with sealing their entire records of all of their investigation and everything else that they do. And I don't know, there's no teeth in the statute either, as far as I know. As far as, okay, if the agency doesn't receives the notice to seal and they don't do anything and then they subsequently use it, there's nothing in the statute that says what are the consequences for doing that, for example. That's not there. So I see a lot of that over the years come through. But I don't know how you get around what Judge Walker's last comment was about. By sending out the notice to seal, you've created that another paper trail of information that there was a record to begin with, right? And so I don't know how you get around that one, because then you send another notice out to the agency to seal the notice they got before. There should be some way of having that in the notification, and quite frankly, I'm not sure if that language is in there or not, but if it is not, maybe that's something that we should consider adding to our statutes here in Nevada about dealing with that loose end, so to speak, as Judge Walker pointed out.
Well, the good news is we have a Children's Commission meeting on Thursday and a Juvenile Justice Oversight Commission meeting on Friday. And although we have much more emergent things to talk about, Bill, I know you'll help me in the JJOC remember to at least place a bookmark about this. I think Master Dollinger gives us sort of the prototypical example. The kid's case isn't sealed. They then get arrested as an adult. P&P goes and looks at the juvenile files and includes the child's disposition that should have been sealed in the child's adult criminal record, and now it's perpetrated to perpetuity. An example that I share to Judge Voy's point that's very personal to me is this. I've said this publicly many times, so I'm not embarrassed to admit it, but I was arrested as a juvenile. That was automatically sealed in the state I was in California. But when I joined the military as a 19-year-old, I didn't know that I could honestly say, when the military asked me, have you been arrested as a juvenile? No. So I was honest and answered yes. When I then got my secret security clearance, when I became an officer in the military, I reiterated that self-disclosure of my juvenile arrest. So 35 years later, I'm interviewing with the governor of the state of Nevada and telling him about my self-disclosed juvenile record that I had spoken about when I gave my bar application, right? So I don't want to make the story about me, but this is real life for kids. It does haunt kids. And to Bill's point, we've got to be meticulous. I don't know what the answer, Bill, is about how do we avoid making a record where the kid might not even have a record by ordering that they seal whatever they've got. So to Master Dollinger's point and Judge Boyd's point, we're going to have to follow it up with legislation. Any other thoughts? Justice Seda, I'll turn it back to you.
I want to be sure, Jessica, that we're covering questions. We're rapidly running out of time. I think we might have one more slide, but it's clear to me that we may not be able to get through it. I'd rather answer questions before we get to our slide, if there are any.
There are no other questions that have come in.
I think that
So we have.
I think we will go on. Just a recap, as I've been doing in each section. The record sealing is not just, it's a part of our form and it's our order. I think as both Judge Boyd and Judge Walker pointed out, very real life paper document, the successful trajectory of our kids when they come out of our system. And so indeed, it's gone on the agenda for the commission as well as JJOC. I'm sure Judge Walker, as you chair that, we need to keep on top of this. This isn't something that we should be cavalier about. Again, you see the key points in front of you on the PowerPoint. Our last slide was pretty simple. We talked about judicial engagement in the community. I believe that's our next PowerPoint. Oh, yikes. No, this is far more important. The waivers to the adult court and what role the judges play. Judge Walker, the 3-minute version of that, or 2 minutes?
Just to say that we actually haven't 30 for this, how long we had people block out.
Great.
For. So we do have 30 minutes.
Oh, great. Okay. All right. Good. Then you can have the full version, Judge Walker. Waivers to the adult court and what role do the judges play?
So there are 2 general statutory provisions that apply. In a moment, I'll take you to 62B 330 and 62B 390. We'll have a brief discussion about, as it were, the law, but then I'd be very interested in a robust discussion with Judge Voy, with Master Dollinger, with Master Carr, and the others about whether the statutes are really good for kids. I mean that as a provocative question. But you see, of course, 62B 330, we have this hybrid system in Nevada. There are case types and factual circumstances that are removed from the judge's jurisdiction. So each of the, if you look at subparagraph 3, each of the following acts shall be deemed not to be a delinquent act, and the juvenile court does not have jurisdiction. Generally, of course, murder and attempted murder, sexual assault and attempted sexual assault where force or violence is used, category A or B felony, if there is a resulting death or substantial bodily harm on a public school premises, etc. Interesting philosophical conversation about should a 16-year-old who attempts a murder or attempts a sexual assault be outside the jurisdiction of the juvenile court. You have in your document some national best practice standards promulgated by the National Council of Juvenile and Family Court Judges, which opine that, for example, there should be no automatic or so-called auto-cert of children. Be an interesting philosophical dialogue that I hope we can have. 62B 390, of course, reinforces the certification proceeding for judges when the state can still charge a child in either the juvenile system or the adult criminal system. and some of the circumstances that remove children from being charged outside of the juvenile system or seeking certification related to those juveniles. We all are familiar, of course, with the 7 minors case and the factors to be considered in 7 minors. But now I think it would be useful, more useful than you all hearing me talk, to have a kind of philosophical dialogue, which I invite you to start off, Justice Seda, having seen juvenile cert cases in the Nevada Supreme Court, about, are we doing the best thing for kids with this matrix? Does it make sense that the legislature has excised, removed whole cross sections of the most serious and therefore cases that call for the most discretion, criminal conduct from the jurisdiction of the juvenile court? Justice Seda?
You've seen some of my writing on this subject. I am a strong believer in judicial discretion, especially in these very specialized areas. I have felt very strongly about taking the authority away from him or her, because they are far better equipped to deal with the youth, the 15 or 16-year-old youth that finds themselves in this very, very serious situation. You know, of course, I also have to mention one of my concerns in this area has to do with prosecutorial discretion to charge, because the charging document or the ultimate charge that brings the child before the adult court can, instead of allowing for judicial consideration and discretion, can be taken immediately out of the hands of the judge based upon that statutory exclusion. I think it's appropriate for me to say that when I sit as a senior judge, I will follow the law, obviously, but that I have deep concern about taking jurisdiction out of the hands of our judges who are specially trained in this area, absent a very, very good reason. I understand the murder charge, I understand that. But some of the other charges, I fear, as I said, judicial discretion should be a part of the process, and in some of these instances, prosecutorial charging can otherwise affect how the trajectory of this child will proceed. I'm not sure exactly, Judge Walker, if that was how you wanted me to provoke the discussion. I know that all of us on this information feed prefer to have discretion left to us to decide. Judge Boy, is there something that you'd like to add?
So before you jump in, Bill,
I will. Well, since I've probably
hang on a second, Judge Boy.
presided over more certification than, huh?
Hang on a second, Judge Boy. Judge,
No.
go ahead.
Yeah. All I was going to say, Bill, is I know you see more of these than anybody else in the state, given the numbers in Clark County. Let's be clear, this is a philosophical conversation, right? Not a political conversation. So I don't want to get myself or Judge Boy in any trouble. But give them the lay of the land, Judge Boy, but also point out, if these kids are removed from our jurisdiction, you, me, Judge Rob, and the other judges, they get put in one place in the state, which is coincident with, i.e. the same place as adult criminal actors. And there's that dirty underbelly as well. So go ahead, Bill.
No, thanks, Judge Walker. I was going to say, yeah, I have probably presided over more cases than anyone else in the history of the state. And most of the case law that we currently have on certifications and transfers has come from my courtroom over the last 17 years. Not because I have a tendency to create more law that way. It's just that for the first time, when I first came over in 2004, we actually had enough public defenders so they could actually file a writ and actually take it to the Supreme Court. Part of that, they were so undermanned, they could barely handle the cases in the courtroom, let alone think about even doing a writ or an appeal. My point being is that there's two areas that really need to be looked at. One, the automatic transfers, which is really a policy statement left to the legislature, with us as judges helping to guide them and educate them. But the legislature has to make those calls. as it relates to the certification process and what we have to follow based upon the case law and the statute, I find that, it's time for the Supreme Court to step back and maybe rethink and relook at the 7 minors matrix. I found it to be archaic and really doesn't address some of the real issues that are really germane to our time and what we do and what our current challenges and the current decision-making process as to whether a kid should be transferred or not, for example. It's time for at this point for that to be looked at, in my opinion. A new matrix that's more geared towards the modern day issues that we face today. I just, for example, I've had my cases are being covered by Judge Hardcastle right now, and there was a 12-year-old apparently in front of him this morning, and he came unglued because that's a legal term. Because he had to order 200 hours of mandatory community service for a 12-year-old, and so. Those are the kind of things that pop up, and I don't know about some jurisdictions may be easier, but down here in Clark, trying to get legitimate public community service, statutory community service, not helping your neighbor out, but real statutory community service, which is required by the statute for a 12-year-old, is almost nearly impossible. And so, again, the transfer area is so important, and it needs to be definitely looked at both on the judiciary side as far as when it is a so-called discretionary transfer, what does that look like, and what us as judges should be looking for in making that final determination, and then the automatic transfers that occur, and that's really the purview of the legislature, who needs to take a look at that. They did when they changed the murder and attempt murder statute session before last, I believe it was, almost 2 sessions ago. And I think it's time, because other jurisdictions, for example, because we still have the old matrix where we can make a decision based upon the severity of the crime itself, right? I mean, that's still under 7 minors matrix. Well, in a lot of jurisdictions throughout the United States had similar types of either statutory or case law criteria, have struck those down. And so for the last several years, I put in my orders that I've always considered and will continue to consider until otherwise by the legislature or the Supreme Court, even in the most heinous of cases, the so-called subjective factors in the analysis. Other jurisdictions call it, they have different names for it, but it's basically the same issue. Those individual characteristics of that child and its circumstances, the crime, because not all the participants' levels are the same, right? And so considering all that, and so it's time, and it's been time for quite some time. My favorite word to say. To relook at that at both ends, both in the judicial side when it comes to what are we supposed to consider, but more importantly on the automatic transfers. Does the legislature need to look at that, and us as judges need to help them and guide them through what those issues are and why it might be best for the judiciary to have discretion in some of these automatic transfer cases.
Yeah, if I could weigh in and echo that, thank you, Bill. I agree with your comments. So Master Carr opines, for example, what do I do when I want to guide or lead a child in the right direction, i.e. towards successful integration into society, but I know by either automatic transfer, they're not in my jurisdiction in the first place, or discretionary transfer, I have one resulting placement, and that is at a medium security adult prison where the children get limited therapeutic intervention, limited schooling, and limited resources. Here's my thoughts, just to say that I'd be curious to know yours or the thoughts of anyone else, more importantly, on the panel. As a juvenile judge, I have to ask myself, what is going to make the community a healthier, safer place? So I've got a kid alleged to have committed a murder and attempted murder, for example. Very serious, very heinous cases, to be sure. The range of penalties that child is going to receive in the adult criminal system do not include the death penalty or life without, quite appropriately, pursuant to the United States Supreme Court's admonitions. So the child's going to get a term of years with parole eligibility or life with parole eligibility, but the child's going to get out, right? They're going to return to the community at some point in the future. And am I going to have a healthier, safer community if a 16-year-old, immature, high-risk, high-needs kid commits an impulsive act at 16 and then are released to the community at 36 years of age with no education, no real psychological or therapeutic intervention, and no life skills? That, I think, is behind Judge Carr's comments and my concerns as well. What are we accomplishing, right? If the goal, obviously there's retribution, there's specific deterrence, there's general deterrence, there's all the traditional goals. But fundamentally, like I know Judge Voy does in his practice and others, I always try to ask, how can I make my community a healthier, safer community in the interventions I provide to this child? Those are just my philosophical thoughts. Maybe I can provoke some comments from others.
So I think I hear you saying.
This Judge Voy, I'll totally share that. I totally agree with you, Judge Walker. That is the issue. And we've been talking about this for 10 years. When the Supreme Court convened the first commission back in 2010, regionalization was a big issue. But this issue we're talking about right now was also a huge issue that we explored and explored. And we've done a lot of talking and over the years, and the only real change that we've had since then was the attempt murder rule that now gives us the discretion under the age of 16 to certify into the adult system. But the linchpin of the whole issue, in my opinion, because you're totally right about that now 36-year-old that gets out of prison, because all this is national statistics and national studies showing the recidivism rates are double, if not even more than that, for someone coming in at that age and coming back out at age 36, for example, and the lack of success there, right? And from a community safety standpoint and everything else. We are all or nothing state. We have 6 months in a open, almost, our so-called correctional facilities, which, other than Summit View, are more akin to military boarding school type layout than it is anything else. So a kid is, let's say a 14 or a 15-year-old has murdered someone, and your option for community safety is retention in the juvenile system, 6 months out of the community, then they're going to be back home, right back in the community. We have an all-or-nothing system in Nevada, and other states have explored this and have developed different hybrids out there. And there's as many states as there are out there, as that many different hybrids. And we still have not made any progress in coming up with a middle ground that would actually try, at least attempt to deal with the issues that we all know exist out there that we don't talk about. That 16-year-old going into the adult system, what they're going to be looking like coming back out, right? And that it's like the dirty little secret. We don't want to talk about that. Well, it's time to talk about that and say, okay, so if you want us to from a policy standpoint, keep more kids with these kind of offenses in the juvenile system, or at least consider that, then you've got to give us some additional tools. When they changed the statute to allow us to keep a child attempt murder under the age of 16, they gave us no additional tools whatsoever to satisfy our second prong of our analysis, which is we have to balance consistently public safety and best interest of the child. That is paramount under Chapter 62. We have to balance that. And public safety and the issue of whether or not we can craft a dispositional order to satisfy the public safety portion of it. And that is going to be a consistent problem until we finally get this addressed and come up with a middle ground, I think, on programming, whatever you want to call it, on how to deal with kids with these extremely heinous offenses that have occurred.
So I'm going to risk the eternal optimism that I have always kept in my toolbox. We have a unique situation right now in the state of Nevada, across the country, frankly, with budget deficits, and the inability certainly to suggest any type of systemic change that Judge Boy and Judge Walker are talking about. I'm going to flip that this way and say that we have a unique opportunity because of the fact that we know there can be no meaningful changes in placements or facilities, educational programs, vocational training for our kids in this upcoming legislative session. We have a unique opportunity to be mindful and very considered in what we would like to be looking at for the next session. Best practices and those hybrid systems, Judge Boy, that you mentioned, let's bring them in. Let's take a look at them. Let's decide whether or not we can ultimately make them work in Nevada. This is the time to be considerate of what is available to us, knowing that there will come a time when our budget will be back full and strong and not in recovery from a pandemic. But I think it's our obligation. I guess this feeds into the next section of our presentation. What are judges supposed to do in the community? You all are absolute subject matter experts on, Judge Walker described the dilemma of that 36-year-old kid that comes out with no education, no training, and is, by statistics, quite likely to return to the adult system yet again. Judge Boy speaks to the extraordinarily difficult balancing that has to be done in terms of disposition, best interest of the kid versus safety of the community. You said it well, Judge Boy. What tools do we as jurists have? Now is the time for us to take up that cause and to figure out what the next 4 years might look like for us and how we can change our system. And again, I preface this with, I am the eternal optimist here, but I prefer to look at this as an opportunity as opposed to an ongoing problem that we talk about generation after generation. Now's the time for us to talk about those sentencing options, placement, mental health services, facility changes, and I go to my grave with that mantra that it's our obligation to take up this cause. You got subject matter experts in every one of these virtual windows here that I believe could bring a change to our state. I think that was a lecture. I didn't mean it to be that way. I meant it to be a call to action. Jess, do we have questions in this regard having to do with waivers to the adult system? We know what the problems are in our current statutory and case law provisions. What else should we be looking at?
So there was just one more comment that came in that says, what about the person who is placed in custody for abuse and neglect, graduates to the delinquency and isolation, and then becomes an adult who spends time as a guest of the state? Many of these folks spend their adolescence and adulthood as guests of the state, not learning how to live in these institutionalized settings. And I think you touched on it a little bit with this idea that we really do have a population of people who aren't able to reintegrate easily because of their habitual institutionalization. And is that really a reentry challenge then, or do we start even further upstream?
Well, I'll jump in and say one of the things about Nevada that I'm an optimist about, I'm going to curse and I apologize, but in Nevada, we're small enough that we can actually get crap done. We're not so big that we can't, that the inertia of the institution prevents it. And what's been intriguing and striking to me is at the end of the day, how closely aligned we all are. So Judge Boy and I work in very different jurisdictions, both in size, in politics, in funding, et cetera. But I think it must be remarkable, I think you would agree, Justice Seda, to see at the end of the day how much judges and courtmasters across the state agree with what the needs are. The hardest sell for me, and I think for Bill Voy over his 17 years and you over your many more than that, Justice Seda, is how do we convince, and I'm convinced there is a way to do it, but how do we convince the executive and legislative branches that they either let us spend money on kids or they are going to spend money on dysfunctional adults? that is a guarantee. It just is as sure as the sun rising tomorrow that for kids who have elevated risks and elevated needs, if you don't give Bill Voy and Bridget Robb and Egan Walker and Gabby Carr and Mike Montero and all the judges across the state, if you don't give us tools on the front end, pretty much I can guarantee you that those of us who also do general jurisdiction are going to send those kids to prison on the back end.
Well, you have well stated the next slide. And the answer is if they don't give us the money for our systems or the tools for our system, they'll be paying for it at the other end. We all know that. We've known it for decades. So the answer to that question comes in this last and closing section of our presentation. How can we be leaders? Educate, educate, educate. And not just in the 6 months before the legislature. That's why I pointed out that I think we have a unique opportunity in the next immediate future, not for this legislative session. We have to be in the community, in our local communities, talking about how our hands are tied with these kids and what our obligation is as a jury to protect the community, to serve the best interest, and how oftentimes we to make those two concepts find their own equilibrium. I think we attend as many school board meetings that are not just about pandemic issues as possible. I think we make ourselves available as local guests on radio stations, TV stations. I think we join forces with the Boy Scouts, the Girl Scouts, all of the community service entities that encompass our young population. I think there's a number of ways we can write editorials, we can create blogs without stepping on any of our ethical obligations not to talk about a case that is in front of us. We are talking about a system. We are not talking about an impending or pending case. We have to be the voice of the kids that we choose to serve. Judge Walker, Judge Voy, additional comments on how judges can be leaders?
This is Judge Voy. I'll start. I think that if you just look at Chapter 62A, it mandates, I don't have it in front of me, unfortunately, but it mandates that, for example, that the juvenile court shall foster assistant funding and and give oversight to diversionary programs, for example. All right, and so that goes back to where we started from. Your role as a juvenile court judge is so different from the other hats that we wear in other case types that you have an affirmative obligation to be out there to educate the community and advocate for funding for the juvenile court systems, including all the accoutrements that go along with that, whether it's additional funding for a state institution, for example. It's all within that. And this is such a unique place in the judicial world that doesn't exist anywhere else, in my opinion, where you have an affirmative obligation as a juvenile court judge to help educate the public, help educate legislators, executive branch folks on the needs of the community in this area. And I think, and it's difficult for a lot of judges to step outside that role and take that robe off and be out there. But I think to be successful in your community, to build the infrastructure, the volunteer systems, the mentoring programs, everything that you need to make a successful community-based program work, you've got to be out there educating and advocating for this. And so I've always taken that position, and I've always also taken the position is that that if you're not doing that, then I think you're not really serving in the full capacity that you should be in this particular hat that we wear as judges.
I love Master Dollinger's suggestions from the comments. Judges should go view and tour the facilities, both the camps and correctional places. The RTCs where we send our kids, right? If we were a parent and we were going to agree to have our kids go or send our kids to an RTC, any parent would want to see it and know where they're sending their kid. Take the classes that we ask the kids to take, aggression replacement training, for example, so that we can speak in a common language that they've learned in the training they've received, and then meet the treatment providers in our communities. You know, Bill, I couldn't agree more. I hadn't ever heard it put that way, but I couldn't agree more that juvenile courts are actually the first specialty courts created in the United States, because of course they really are. And you do have to have a specialty court mindset. It's funny because I think you would agree, Bill, politically, a lot of new judges or new to being judicial officer, court masters or otherwise, get sort of placed in juvenile court. Either they see it or the people who placed them there see it as a stepping stone to something else.
Well, we can't live in a bubble either. I mean, you've got to maintain your bubble. You've got to maintain your again, it's you've got to walk a tightrope in this area, but you still got to walk it, you know. And I've always taken, and I tell parents this all the time. I said, my goal, my philosophy is I will not send a kid to a place that I wouldn't send my own kid to. And you've got to tour these places. You have to see where you're sending these kids, and you've got to have not you as the judge, but you as whether you're down here up in Washoe in the rurals, your probation officers, whoever, you know, clinical people that work for the court system. They have to be out there vetting these programs and constantly staying on them to assure that the programs that we send kids to are actually doing what they say they can do, and vetting them. So for a lot of different reasons, and so you have to be very active in that, making sure that quality assurance that's there, that needs to be there. And without it, again, we're not being effective at all. But again, conveying that, you know, that importance that the parent engagement, which we're going to talk about later, is so strong of a factor in the success of this child coming into our system and then hopefully getting out of our system and not coming back. And letting that family know that, listen, this is how important I think this is, in treating that kid as if you were sending your own kid to this institution or this program, for example. And I think that's so important in fulfilling your role as the juvenile court judge for your county.
Absolutely, I love this.
I just wanted to add something to the thought that Judge Dellinger created for us. Not only should we as judges go visit and sort of do the quality assurance, you know, take the legislators, take your local commissioners, do a ride-along, if you will, for them, up close and personal. Let them see what we're talking about. I think that is a tried and true. You develop yourself an advocate in that other branch of government by doing so, and you might serve the purpose of opening some eyes to better services. Judge Walker.
So I want to challenge Master Dellinger. She came up with a great comment. Her title, of course, is court master. I also suffered from that title as a court master, and I, like her, hated that title, particularly for purposes of diversity, equity, and inclusion. In this political climate, I'm sure, Master Dellinger, you can find a legislator from Washoe County who would take up a bill draft to rename that position. There is no reason a child, any child, in my opinion, whatever their color, distraction, ethnicity, or persuasion, but there's no reason a child of color should have to address a judicial officer or anyone else as a master. I couldn't agree with you more. I think that's a great point.
Now, Jess, I see we are definitely...
Well, we're just about at our time.
Go ahead, Jess. I was just going to ask.
Do you guys have any final like there?
Let me start by saying what I think is most important. Thank you to the council for allowing us to bring this summit to our judges, and to each and every one of you who are listening. I meant what I said earlier. You are the subject matter experts in all of this, and I thank you for doing what you're doing every day, and I know that we can still do more and do better. Judge Walker?
So I appreciate the conversation so much. It's always good to hear my colleagues' voices, whether by chat or otherwise. I will simply say that when I look back on my career, not just as a judge, but as a judge, the thing that speaks most to me is the welfare of our children. And I'm always invigorated and thankful to be around all of you who share that same drive.
I would really like to thank both of you and Judge Boy as well. Judge Boy, did you want to have a final statement?
No, I think I've said enough today.
I really appreciate you.
Look forward to tomorrow's next cast.
Yeah. Appreciate you joining us today, Judge Boy. I really appreciate Justice Seda and Judge Walker taking the time to walk us through these kind of tricky issues. This is a recorded session, and so it will be something that future judges and hearing officers can also enjoy as they take over these roles and learn from all of this as well. Tomorrow we're going to be talking about screening and assessment, so we're going to be talking about the YLS for risk and need for juvenile delinquency, and then the MAISY and other tools for mental health. And so this will be really geared for, again, you as our judicial audience to understand how you will get that information and what you can expect and how you should use it. We're going to be joined by Dr. Gina Vincent, who is a nationally renowned expert on these tools, as well as Pauline Sala, who works over in Humboldt County, to give us that local and on-the-ground look at how those tools work. So we will see you all tomorrow. Thanks so much, everyone.
Thanks, everyone.